Welcome to my channel, Legal Jargon. I have devoted my channel to be explaining law-related concepts and other current affairs topics relevant for cracking judicial services exams and other competitive exams. Please like and subscribe my channel and hit on the notification button for further updates. In this session, I would be covering the topic of general exceptions under the Indian Penal Code. It is a very important topic which is repeatedly asked in judicial services exams of all states. General exceptions are classified under Chapter 4 of IPC 1860. They are as follows: mistake of fact, given under Section 76 and Section 79, privileged acts under Section 77 and Section 78, accidental acts under Section 80, acts done without criminal intention are covered from Section 81 to 86. Acts done with consent are covered from Section 87 to 91. Acts done without consent, Section 92 and 94 explain such acts. Communication made in good faith, Section 93. Trivial acts is given under Section 95, and right of private defense is covered from Sections 96 to 106. Mistake of fact is explained under Section 76 and 79. Section 76 deals with acts bound by law, and Section 79 deals with acts justified by law. Let us understand acts bound by law given under Section 76. Nothing is an offence done by a person under mistake of fact in good faith. Acts done under mistake of fact are excusable, whereas acts done under mistake of law are not. Under Section 76, a person believes that he is bound by law while committing the act. For example, a servant mistakenly kills his master at night, thinking that a burglar has entered his master's house. Here A will be exempted from the act as he acted in good faith, thinking that he is bound by law and was protecting his master's house from burglary. Under Section 79, acts are done justified by law. So a person committing an offence under Section 79 believes that he is justified by law while committing of the offence. Under Section 76 and 79, no exemption is given if the person does not act in good faith or with due care and caution. For example, A sees B inflicting severe wounds on C. A catches hold of B's hand and takes him to the police station. Here, A is justified by law. But in fact, B was actually exercising his right of private defense against C. So, A is protected under Section 79. Privileged acts are described under Section 77 and Section 78. Section 77 deals with acts done by a judge, and Section 78 deals with acts done in pursuant to a judgment. Under Section 77, nothing is an offence when it is done by a judge acting judicially in the exercise of his power or in good faith given to him by law. The protection is also available to an officer under Section 78, and hence the powers are much wider under Section 78 than under Section 77. For example, if a judge gives a judgment hanging a person or giving a death sentence to a person, even if the judgment is wrongly given, he will be exempted under this section. Act done in pursuant to a judgment is given under Section 78. Here, if, for example, a person acts in pursuance of a judgment, he will be exempted under this section. We can understand this with the help of an illustration where, suppose a hangman hangs a person in pursuance of a judgment given by the judge. Then he will be exempted under this section.
Accidental acts are covered under Section 80. They are unexpected or unintentional acts done without criminal knowledge or intention. Act must be done in a lawful manner using lawful means with proper care and caution so that it deserves an exemption under this section. For example, A is a stuntman flying off a building on a bike, and in the process he kills and injures a person. If he is taken due care and attention, due care and caution while carrying out the act, he will be exempted under this section.
Acts done without criminal intention are necessity, described under Section 81, infancy, described under Section 82 and Section 83, insanity, under Section 84, drunkenness, under Section 85 and 86, and Sections 92 to 94. An act of necessity is provided under Section 81. Nothing is an offence when it is done with the knowledge likely to cause harm without criminal intention. It is done in good faith for preventing or avoiding harm to person or property. The harm here must be of such imminent nature that the act done with the knowledge and without criminal intention is excused. For example, A is the captain of a ship. He maneuvers the ship away from an iceberg, which is in the nature of immediate danger, to collide with a smaller boat close by, killing 30 people present on board. He does this so as to avoid the killing of 1,000 people on the ship and kills 30 people in the smaller boat. So, an act of necessity can be understood as a minor offence done to prevent a major harm. Acts committed by infants are covered under Section 82 and Section 83. Section 82 deals with a child below 7 years of age, and Section 83 deals with a child above 7 years of age and below 12 years of age. Under Section 82, a child is given complete exemption who is under 7 years of age, as it is scientifically proven that a child below 7 years of age cannot be guilty of an offence or cannot have the necessary mens rea to commit an offence. That is why it is the presumption of law that he is doli incapax. Whereas a child above 7 years of age and below 12 years of age under Section 83 is given partial exemption. This is because the court will then look into the maturity levels of the child to understand whether the child had the necessary guilty intention to commit the crime or not. For example, a child of 9 years stole a necklace and sold it in the market. Here, it can be understood from the acts of the child that the child knew that his act of stealing the necklace is wrong or contrary to law, and he had a guilty intention while committing the offence, and the subsequent act of selling it in the market proves this. Here, the court will presume the child to be guilty, and that is why there is only partial exemption given under Section 83. Section 84 of IPC deals with insanity. Insanity can be of different types. Lunacy, idiocy, disease, and drunkenness fall within the ambit of insanity. Insanity is provided under Section 84. It exempts a mentally abnormal person from criminal liability. Nothing is an offence which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or what he is doing is either wrong or contrary to law. The court, while granting an exemption under this section, looks into legal insanity and not medical insanity. It is based on the famous M'Naughton's rule. The burden of proving insanity falls on the accused. The acts of drunkenness are covered under Section 85 and Section 86. Section 85 deals with involuntary drunkenness and Section 86 deals with voluntary drunkenness. The acts under Section 86 are not exempted whereas the acts under Section 85 dealing with involuntary drunkenness are exempted. Let us first understand involuntary drunkenness given under Section 85. It is defined as nothing is an offence done by a person who, at the time of doing it, by reason of intoxication, is incapable of knowing the nature of the act or what he is doing is wrong or contrary to law, provided that the alcohol is administered to him against his will or his knowledge. Here, the most important thing is the act of administering alcohol has to be done by a third person and against his will. A landmark case under Section 85 is Director of Public Prosecutor versus Beard. In this case, the accused had committed rape on a minor girl and caused death of the girl by suffocation. The court rejected the plea of drunkenness taken by the accused under Section 85 and convicted the accused. Under Section 86, it deals with voluntary drunkenness. Such acts are not excusable under law because the incapacity is by one's own act. Acts done with consent are covered under Section 87 to 91. Section 87 deals with acts done with consent. You can remember a fencing match as an example under this section. Section 88 deals with acts done for protecting the victim's life. An example here would be a surgery committed on an adult person. Section 89 is acts done for the benefit of a child or an insane person. Here also a surgery by a doctor performed on a child. So the consent of the guardian is taken under Section 89. Section 90 deals with consent given under fear or injury of misconception of fact with regards to an unsound or intoxicated person or a child under 12 years of age. Here consent is not given freely. There is some sort of coercion or influence used under Section 90, even though consent is given. Under Section 91, the act itself, independent of the harm caused, is so severe that it is to be punished. It is severely punished by law. For example, an act of miscarriage is punished severely under law, and it does not matter whether the consent was given by the woman or not, unless it is done to save the life of the victim. Section 87 can be understood through a maxim, through the Latin maxim, voluntary non-fit injuria. One who consents suffers no harm. Here the consent to suffer must be to any harm other than death or grievous hurt. So except death or grievous hurt, the person must consent to suffer any other harm. The consent must be given by a person above 18 years of age. So it is necessary that it has to be given by an adult. The consent can be express or implied. Examples to voluntary non-fit injuria are fencing matches, boxing matches, football matches, where people suffer injuries other than death or grievous hurt. Section 88 deals with acts which protect the person's life. Here, the consent is given by a person above 18 years of age, that is an adult person. Any other harm other than intentional death is caused. So even death can be likely be caused, but it should not be intentional in nature. It should be done in good faith and for the benefit of the person. For example, a surgeon performs a particular operation on Z that it is likely to cause his death, but without the intention of causing Z's death. For his benefit, under good faith, A has committed no offence and will be exempted under this section. Section 89 deals with acts done to save the life of a child under 12 years of age or of a person of unsound mind. It protects harm caused to a person below 12 years of age or of an unsound mind by taking the consent of the guardian. Here the act should be done in good faith for the benefit of the child, and the consent may be express or implied. Here also the harm can be any harm except intentional death. So if surgery is performed by the doctor on a child below 12 years of age or a person of unsound mind by taking the consent of the guardian where the act of surgery can likely cause death of the child or the unsound person, then the surgeon will be exempted under section 89. Section 90 deals with acts where consent is given under fear of injury or misconception of fact. Here consent is not freely given and it is given under fear or injury or under misconception of fact by a person of unsound mind or by a drunken person, a child under 12 years of age, or under fraud, misrepresentation, or coercion. Let us take an example under section 90 of a group of dacoits who ask a key maker, to make a key to open a house which they want to steal from by putting the person in fear or injury of death. Such an act of opening or breaking open the lock by A is exempted under section 90. Section 91 covers an act independent of harm caused. It's an exception to section 87, 88 and 89 because here the court will not look at the harm caused to the other person. The act is so severe that the court will convict the person based on the offence itself. The consent cannot be extended beyond the harm caused. This can be understood by an example. Causing miscarriage to a woman, even by taking her consent, is so severe in nature that it will be punishable and cannot be exempted unless it is caused to save the life of the woman. Acts done without consent are covered under section 92 and section 94. Section 92 deals with acts done without consent to save the life of a person, and section 94 deals with acts done by a person under force or compulsion. Under section 92, act is done without consent to save the life of a person. Here, due to some urgent work, it is difficult to get consent in time. For example, a surgeon sees a child suffering from an accident proved to be fatal unless he performs an operation on the child. Such a surgery can cause death of the child, but it is not intentional in nature and done under good faith. Here, the surgeon does not have time to apply for the child's guardian's consent. He will be exempted under section 92. Under section 94, an act is done by a person under force or compulsion. The person will be compelled by force or threat of force to do any act. He will be excused from the consequences of any act except murder and offences against the state, punishable with death. For example, a banker is threatened by the mafia that they will rape his daughter unless he helps the mafia in robbing a bank. Section 93 covers acts where communication is made in good faith. Here, communication is made in good faith to a person is not an offence even though it causes harm to the person to whom it is made. It must be done for the person's benefit. For example, a doctor informs a person, an old lady, that she is suffering from cancer. She immediately dies due to a heart stroke. Here, it is not the fault of the doctor as he had made a communication in good faith under section 93 and he will enjoy an exemption. Trifling acts are covered under section 95. It is based on the Latin maxim de minimis non curat lex. Law does not take into account trifles, which is the law does not take into account acts which cause slight harm. The harm must be so slight that no man of ordinary sense or prudence would complain of it. Harm includes hurt, injury, or damage. A trifle act can be determined based on the nature of the act, that the injury caused, the intention or knowledge of the accused. For example, if an accused commits a theft of a check of no value, then it is a trifling act under section 95 and it will enjoy exemption. The right of private defense is covered under sections 96 to 106. Section 97 to section 99 deal with the general provisions of the right of private defense. Section 100 to Section 102 deal with the right of private defense existing against the body. Section 103 to 105 deal with the right of private defense to be exercised against property. Section 97 state that the right of private defense can be exercised against body as well as property. Section 98 that the physical or mental capacity of the offender is not a bar. That, for example, a person who can exercise his right of private defense against a person of unsound mind. Section 99 lay down the general restrictions to the right of private defense. Section 100 states that the right of private defense can be exercised against the body to cause death. Section 101 states that the right of private defense can be exercised to cause any other harm other than death. Section 102 states till when the right continues. So the right of private defense continues as long as the danger to the body lasts. Section 103 states that the right of private defense against property can be exercised to cause death. When can it be caused? When can it be exercised to cause death? Section 104 states that when can the right to private defense against property be exercised to cause any other harm other than death? Section 105 mentions that the right, till when the right continues. The right of private defense is based on two principles: that everyone has a right to defend one's own body and property, and also the right to defend others' body and property in times of immediate necessity or danger. Right cannot be used to cause harm to any other person. Section 96 states that nothing is an offense which is done in the exercise of the right of private defense. Section 97 states that the right of private defense can be exercised against body as well as property. Section 99 lays down the restrictions or limitations to the exercise of the right of private defense. Right of private defense cannot be exercised against a public servant discharging public duties when there is time to have recourse to public authorities. For example, if you have time to go to court and file a case or a suit against the accused person, then the right to private defense is not available. You cannot exercise more harm than necessary. For example, if a trespasser trespasses upon your land, you cannot go on and kill that person. That would amount to more harm than necessary. Section 106 states that the right of private defense is available against innocent persons. For example, a mob is trying to attack you with weapons. You try to scare away the mob by firing on the mob. This act is exempted under Section 106. The right of private defense against body is covered under Section 101, Section 100 to 103. Section 100 states that the right of private defense can be exercised to cause death in the following cases. There are 6 cases which Section 100 deals with. The first is reasonable apprehension of death. Second is grievous hurt. Third is assault, committing rape. Fourth is gratifying unnatural lust. Fifth is kidnapping and abduction. And sixth is wrongful confinement. So these are cases where the severity is so much that one can cause death in the exercise of the right of private defense. Under Section 101, the right of private defense can be exercised to cause any other harm other than death. Under Section 102, commencement and continuation of the right of private defense exists against the body until the danger to the body lasts. The right of private defense against property is covered under Section 103 to 105. The right of private defense against property to be able to cause death is given under Section 103, and the cases against which death can be caused is when there is robbery, housebreaking by night, mischief by fire on a building or a human dwelling, theft, mischief, or house trespass, giving rise to reasonable apprehension of death or grievous hurt. Under Section 104, any other harm other than death can be caused while exercising the right of private defense against property. Under Section 105, the commencement of reasonable apprehension of death, danger to property continues. In the cases of theft, when the offender has retreated with the property or has taken the assistance of public authorities to get the property recovered, the right of private defense against robbery continues as long as the offender causes or attempts to cause to any person death, hurt, or wrongful restraint, or fear of instant death, hurt, or wrongful restraint until it continues. And the right of private defense against criminal trespass or mischief continues as long as the act of criminal trespass or mischief continues. The right of private defense of property against house breaking at night continues as long as the house trespass or house breaking continues. So, with this, we end with the topic of general exceptions. With this, we end this session. If you have any comments or any questions related to the topic, you can drop me an email in the description given below. Thank you for watching this session. I will come up with further videos in the next sessions very soon.